to be educated, but I'm so frustrated. Hello to my loneliness.
Question? Can you hear us?
Oui, en effet.
Okay.
I can hear you.
Okay.
Order à l'ordre. The Public Order Emergency Commission is now in session. La commission sur l'état d'urgence est maintenant ouverte.
Okay. Bonjour à tous et bienvenue à la 4e journée de nos sessions de politique. Welcome to our 4th policy day. Today we're dealing with police-government relations. Nous traitons des relations entre le gouvernement et la police. Alors, nous avons un panel excellent, on m'avise. Alors, il y a certains que j'ai déjà eus plus tôt cette semaine et d'autres qui sont nouveaux. So, with that brief introduction, I'll turn it over to Professor Baker to introduce our panelists.
Thank you, Commissioner, and good morning, everyone. My name is Dennis Baker, and I'm an Associate Professor of Political Science and Acting Director of the Criminal Justice Programs at the University of Guelph. It is my honor to be moderating this roundtable this morning. We have an impressive array of experts here, and I'm going to introduce them briefly, going around the table. Malcolm Thorburn is Professor of Law and Associate Dean of Graduate Studies at the University of Toronto. Next to him is Professor Michael Kempra, who is an Associate Professor of Criminology at the University of Ottawa. Kate Pudister is Associate Professor of Political Science in the Department of Political Science at the University of Guelph. Ryan Teschner is Executive Director and Chief of Staff of the Toronto Police Services Board. And James Raymer is the Chief of the Toronto Police Service. And joining us online is Christian Leuprecht, who is the class of 1965 Distinguished Professor of Leadership at the Royal Military College and Director of the Institute for Intergovernmental Relations at Queen's University. So our topic here this morning is the relationship between police and governments. As Professor Pudister and I can attest, having taught many Guelph students over the years in a class called Governing Criminal Justice, this is a relationship that is fraught with challenges and does not lend itself to easy answers. We know that neither extreme is appealing. The idea of government-directed police force, where the police become an arm of the government of the day, is repugnant to our commitment to the rule of law and threatens our democratic right to express our displeasure with the government. The other extreme, fully independent police, risks allowing those police services to be a force unto themselves, disconnected from civilian control and legitimate democratic authority. The relationship must be somewhere in the middle. But that middle, as my students know and Professor Fuddister's students know, is sharply contested and often difficult to operationalize. So today we're going to talk in some detail about the capacity of governments to direct police, the sharing of information, and the relationships between different police services and the multiple levels of government. My hope, Commissioner, is that even if we cannot provide you with definitive answers today, we can at least assist you by outlining the contours of the debate and where some of the reasonable disagreements may lie. With that, I'm going to turn the session over to our panelists for opening statements. I've asked each panelist to speak for about 5 minutes, introducing their approach to the topic, and then we're going to have rounds of questions focused on different aspects of the relationship. One final reminder to everyone on the panel, speak slowly, something I'm going to have to struggle with, and always identify yourself when speaking for the benefit of our translators and transcribers. So Professor Michael Kempa, I have you in alphabetical order, so you are up first.
Great. Thank you very much for including me, Commissioner. And as you know, the issue of political engagement and civilian oversight engagement with policing has plagued the Canadian system since the MacDonald Report in 1981. It's over 50 years, but I have every confidence that we will resolve these issues here today and through the work that you'll do on the Commission after all this time. I approach policing basically as a window into politics and political economy, which is simply to say the way that a society sets up its policing system, divides responsibilities between public policing authorities, private policing authorities, and civil or volunteer policing authorities says a lot about their broader views of the proper role of the state generally, what a market is and what its purpose is, who it serves, what a civil society is and what a civil society can contribute to the broader political economic context, how to define citizenship and how rights of citizens are to be institutionalized, including who is included and sometimes accidentally excluded from these regimes of rights. So that's at the theoretical level. At a practical level, I'm simply interested in who makes the decisions around policing policies, operations, and the exercise of policing power. And my general concern is that all three of these things are as democratic as possible, which means as close to community as possible, as reflective of community values and needs as possible, balanced by the need for the exercise of policing power as a form of legal power to be independent and democratically accountable. Now, the way that those things come together in different circumstances will vary. The answer will not always be the same depending on what type of policing powers we're talking about and what circumstances. But generally, by interrogating those questions, you get a good window into democratic theory and political economic theory. Thank you.
Thank you, Professor Kempa. So next up is Professor Luprecht, who's on Zoom.
Yeah, so if we frame the problem here, donc merci de l'invitation aujourd'hui. So we had a modest but tenacious protest in Ottawa, and the system comes under moderate strain and is unable to come together to achieve strategic effect. I mean, we get more people in Kingston for homecoming than we did in Ottawa for the Convoy. So let's think about that. So Police Services Acts call for adequate and effective policing. What does that mean? It means policing the response to the needs, values, and expectations of the local community. On the other hand, police swear an oath to protect life, property, and prevent crime. So the question for police is, what's the best way to keep the public safe? And you can already see emerging here the fundamental problem, which is the delta between public expectations on the one hand, as well as the quantity and the quality of policing. And I would say that delta in Canada continues to grow. And so we can use the Ottawa Convoy as a critical case study and a laboratory of experimentation of generally what ails the national security system, because what we have here is a fundamental failure of the entire intelligence, law enforcement, and national security system. So police resources are always oversubscribed, even in normal times, and so they'll follow risk. And so that means that police planning, decision-making, and action depends on the intelligence cycle. Planning and direction, collection, processing, analysis and production, dissemination. We had multiple agencies generating those: CSIS, the RCMP, Criminal Intelligence Service of Ontario, OPP, OPS, open source through media, and it seems we never were able to come together to actually produce a coherent picture. Just think about who would let all these trucks downtown after the World Trade Center bombing in 1990 and the Oklahoma City bombing in 1998. So there's four, I think, key elements here. The issues with regards to the chief in Ottawa, I think, are more symptomatic of broadly issues in Canadian policing when it comes to police leadership, police management, police institutional culture, and policing posture. Issues with regards to the board are emblematic of challenges of police governance more broadly, but also what happens when we don't have adequate police governance. We have interagency issues of, and in particular, police didn't ever appear to have an appreciation of the totality of circumstances that affected this situation. And we have intergovernmental issues where the premier, the prime minister, and the mayor should have stood together with their chief law enforcement officers, and instead we got squabbling among them. All this in the capital of a G7 country. So the system was unprepared. And so I think what we get here, this was more symptomatic of a number of broader issues. One is we have good incident response among law enforcement in Canada. We have difficulty with sustainment. In particular on issues of intelligence, planning, and logistics that a medium-sized police service such as the Ottawa Police Services cannot simply be expected to have for national protest. That's where we need national and to some extent provincial agencies to come in. Where was the RCMP surge capacity? We're always told we have this national police force of 17,000 people, so we can surge in times of a crisis. Between A Division, C Division, O Division, and headquarters, we have well over 2,500 people that could have simply gotten in their cars that are not on frontline patrol. Where were they? We had a loss of trust and confidence by the public that caused politicians to meddle. We had issues of outdated policy, which are governance issues. There's a broader debate about what constitutes national security. We have this very realist and traditional approach that I think does not do well in coping with economic security and political stability, issues of hate crime, ideologically motivated violent extremism, and so forth. 6, we have a reactive national security posture in preserving national security when we need a proactive and intelligence-driven one, where federal agencies have to have a firm and clear understanding of their mandate and on issues so that they can clearly advise local agencies. And I'd say there's a general vulnerability that was created in Ottawa, where this vulnerability to public safety and national security then create multidimensional issues of destabilizing Canada and its democratic institutions more broadly. The conclusion is that the Emergencies Act shouldn't and wouldn't have been needed had the system performed well to achieve strategic effect. The fact that the Emergencies Act was invoked is an indictment of the system and its inability to perform for Canadians, for the government, and for local citizens in Ottawa.
Thank you, Professor Leprecht. I'm going to remind the panel to please try and speak slowly for the benefit of our transcribers and translators. Professor Pudister.
Thank you. Good morning. My name is Kate Pudister, and I'm an associate professor in the Department of Political Science at the University of Guelph, and I'm pleased to be here with you today. My research and teaching are in the areas of law and politics and criminal justice policy. With colleagues, I have researched and written on several aspects of police governance and accountability. This work includes a study of the RCMP's Mr. Big undercover technique as a test for various types of police oversight for a routine but covert policing operation. My current research examines civilian police oversight in Canada with a focus on Ontario in particular. I've written on the investigation, prosecution, and sentencing of police officers in Ontario and the work of the Ontario Special Investigations Unit as a method of police oversight and accountability. My work demonstrates the very complex and challenging nature of these cases for the justice system. Through my work, I try to highlight the importance of public legitimacy and police oversight and the various sites of accountability for police. My research has shown that for some matters of policing, parliamentarians, responsible ministers, and police oversight agencies either show little interest or are incapable of regulating police conduct in an ongoing basis or in approaches that are more systematic and comprehensive in nature. To this end, there are examples of elected officials in Canada being unwilling to take on difficult matters of police policy and operations, instead choosing to rely on a notion of police independence that is too expansive and unhelpful for effective democratic governance of policing. I see my role on this panel to think about connections to police accountability and civilian oversight with respect to police-government relations. In thinking about this topic, we are often presented with discussions about the importance of police independence and the dangers if police independence is not taken seriously in a democracy. Too much government direction of the police and overreach presents a problem for the rule of law, but too much police independence raises issues for democratic accountability and other problems for the rule of law. This conversation usually turns to distinctions between policy, something that is the rightful domain of governments and police service boards, compared to operations, something that is the rightful domain of police themselves. I know that we'll discuss these issues further this morning, but my perspective is that this distinction and an attempt to draw a clear line between the two does a disservice. This focusing on the distinction between policy and that of operations leaves out critical conversations about the role of the public through civilian oversight and the importance of other sites of accountability, such as the courts, the media, and inquiries like the present. Importantly, this formulation allows governments to shirk responsibilities with respect to policing, perhaps as a method of political strategy, instead of having a more nuanced discussion about the respective roles of each and how this might change based on the nature of policing that is required, considering the wide scope of responsibilities of the police. Police in Canada are tasked with a wide range of responsibilities as laid out in legislation: crime prevention, law enforcement, assistance to victims, public order maintenance, and emergency response. Each comprise different and occasionally competing demands. When thinking about the governance of the police, there's value in having a nuanced conversation about these different roles and how police independence or operational responsibility might take on a different meaning and importance. Perhaps there's a greater role for government oversight when responding to issues of public order policing, compared to the core responsibilities of the police to investigate a particular person or persons and to lay charges. My perspective is that there's value in establishing through public policy the responsibilities of both government and the police, to articulate the accountability mechanisms, to define procedures of communication, information sharing and direction, and so we can identify cases of undue influence if they deviate from these guides. Enacting policy and legislative guidelines can promote openness by allowing for the setting of policy priorities, debating the direction of those priorities, and for policy evaluation, all of which can be aimed at ensuring democratic values and principles are alive and well in Canadian policing and police policy. Clear rules can articulate lines of accountability and oversight, which can not only guide police-government relations in the future, but it can also further public confidence. And with that in mind, I look forward to our discussions this morning.
Thank you, Professor Pedister. I'll call on Chief Raymer.
Good morning. Let me first thank you, Mr. Commissioner, for inviting me to participate in this very important exercise. I am a lifelong practitioner, having devoted my working life to policing, public safety, and crime prevention. I hope that I can provide some insight into how theory is applied. The title of this session is Police-Government Relations. The essence of the discussions is how do we construct and reinforce public institutions that preserve and promote democracy. I firmly believe that democracy is more than just voting. Many institutions promote democracy and the balancing of rights. Some institutions, however, can promote democracy or detract from it depending on how they are administered. Policing is one such institution. In my view, we must be careful to avoid adopting strategies aimed at remedying a particular problem that tend to undermine a system that, generally speaking, works well in this province and across Canada. A system of policing that is independent of political interference is a system to be protected and nurtured. It is a key aspect of democracy. It must, of course, be accountable to the people, and the leadership must be responsive to the people and ensure that the rule of law is maintained. The police cannot be seen as a tool to be used by any particular government, but must be seen to be operating on the basis of democratic principles. The leadership in policing need to be experienced, trained, empathetic, and humble in order to be effective. Long ago, in response to political interference in Toronto, born of divisions transplanted from abroad, the provincial government created a police commission designed to protect the police service from actual and perceived interference. That system has evolved into the Police Services Board system we have today. That system has evolved and matured to ensure that politics does not intrude into operations, but that the direction of policing is responsive to the legitimate needs and expectations of the people. I am of the view that while I accept there is room for improvement in the system we have developed in Toronto, we are currently positioned as well as we ever have been to ensure responsive, accountable, and independent policing for the people who depend on us. The service embraces the role of the board. We do all we can to ensure they have the information and assistance they need from us to fulfill their role, which is often stated to be ensuring adequate and effective policing. I am sure Mr. Teschner will unpack that concept over the course of our time together, but for me, it includes providing the service with policy direction that informs our operations. It is a relationship that recognizes that the board can and should collaborate with the service and can do so in a way that augments its oversight ability and does not detract from it. The service has also matured, and we realize that the board can provide unique civilian perspectives that actually enhance our operations. So we have policy and operational discussions frequently, and each of us are the better for it. However, a key to those discussions is that we each honor the other's roles. The board also plays a key role for the police in being the contact point with government. The board is, in that respect, another key democratic institution. The board allows the government to learn of some aspects of policing and even questions operations with the board. Thus, the government will not be seen as directing operations or attempting to do so. The board also assists in resourcing in concert with the service and assists the service in speaking to government in terms of powers and authorities that would assist the police in carrying out their duties. That encapsulates my view on police-government relations, and I look forward as well to today's discussion. Thank you.
Thank you, Chief Raymer. Mr. Teschner?
Thank you, Professor Baker. Good morning, Mr. Commissioner. Bonjour. I have spent over a decade focused intensely on police-government relations, first as a lawyer, then as lead counsel to Judge Morden for the G20 review, and then now a front row seat as Executive Director and Chief of Staff to Canada's largest municipal police services board. And so I have some reflections. I approach this as a discussion of principle, and there are three that I think animate the approach to effective, appropriate, well-balanced police-government relations in Canada. The first is an acceptance that we must keep politics out of policing. Law enforcement decisions, in their core fashion, should not be made or directed by those in elected office. Police officers have common law authority independent of government and must undertake their core law enforcement functions separate from government direction in order to maintain the rule of law. But we have to be careful not to lean too heavily into creating a bubble of immunity that prevents governance and oversight of police in terms of their plans, actions or inactions, or otherwise impedes the flow of information essential for governance and oversight to function. The second principle is that we need governance and oversight in some form. Policing requires, in my view, some form of independent governance that is forward-looking, that is prospective, and that embeds due respect for community norms. We need this to maintain the public approval required for democratic community policing systems to function. It helps ensure that the public's accepted values and norms, as many of the other panelists have mentioned in their intros, guide the delivery of policing. And it puts in place the policy infrastructure that sets the rules and limits within which specific law enforcement decisions will be made and actions taken. We also need independent oversight, after the fact accountability processes that examine decisions or acts once they have already occurred and help us learn from them. Third principle is that we need an intermediary who mediates and sometimes arbitrates interests. There must be a way to, without government being the decision maker improperly, translate public values and expectations into a framework within which policing services will be delivered. Someone must balance competing interests of different constituencies, a diverse public, police leadership, elected officials, oversight actors, interest groups, but ultimately make the policy decisions, set the priorities and objectives from which police actions flow. There are a few other key points I'm sure I'll expand on today. One is that the ability of independent governance and oversight bodies to function and fulfill their important statutory mandate requires a healthy information exchange, and that is not the same as impermissible direction of the police. The second is the need to balance the concepts of independence and accountability in a way that avoids political interference but avoids political shirking of responsibility. And the third is that community connection that the boards and commissions across this country provide help ensure that a community needs and their expectations as they evolve are matched, that there's a feedback loop so that policing evolves alongside. Very quickly, I'll put this by way of analogy. I look at the role of police boards and commissions the way that I look at building a house. You have an architect and you have a general contractor. Police boards are the architects. They have a vision, they develop the blueprints, they set the plan. Police chiefs and police services are the general contractors. They are the experts. They come in and they mobilize the trades, the resources, the equipment, the tools in order to bring that plan to life. Each have an important role. But for anyone who has built a home, renovated a home, you know that you have to respect the roles of each in order for the system to function properly. And I look forward to expanding on that more today. Thank you.
Thank you, Mr. Teschner. Professor Thorburn?
Thank you. Bonjour et merci, Monsieur le Commissaire, pour l'invitation à participer aujourd'hui à la discussion. Je m'appelle Malcolm Thorburn. Je suis professeur titulaire et vice-doyen aux études supérieures à la Faculté de droit à l'Université de Toronto, où je tiens aussi la chaire de recherche pour l'innovation. J'enseigne le droit pénal et le droit de la preuve et j'effectue des recherches sur la police et sa police dans l'ordre constitutionnel au Canada, plutôt sur le plan théorique mais aussi sur le plan pratique. Je donnerai mon discours en anglais aujourd'hui, mais je serai ravi de répondre à des questions dans les deux langues officielles. I'll start my presentation by outlining what I take to be the main concerns that should structure our thinking about police-government relations. I know that many of my fellow panelists are criminologists, police officers, political scientists who have already brought enormous insight into the policy considerations that pull us toward one arrangement or another. I'm going to focus my own thoughts on some of the legal considerations, common law doctrines, constitutional principles, and so on, that I believe should structure our thinking on this topic. And the central idea I want to put forward is one that we've already heard mentioned here, that in Canada, I believe, we have for too long had a rather vague and sometimes often overblown conception of police independence from government. As a matter of common law doctrine and of constitutional principle, made clear in many places our Supreme Court's decision in 99 in Campbell, for example, it is clear that the police should be fully independent of the government, police services boards, ministers, whoever, while engaged in criminal investigation, commencing or ending investigations, laying charges, and the like. That much, I think, is clear as a matter of law, and I think I would agree as a matter of policy. And that is because in these situations, when the police are targeting specific individuals for the attention of the criminal justice system, full independence is essential to the integrity of their operations. Without it, there is a significant danger that the criminal justice system might become a tool of the government of the day. As with other parts of the criminal justice system, impartiality is crucial to its legitimacy. But outside the context of criminal investigation, there is no good reason, I think, to think that the police should be fully independent of government. Indeed, there are plenty of good reasons to think that they should not. So the police have wide discretion, considerable coercive power over increasingly wide variety of different areas, well beyond the scope of criminal investigations. It is, I think, intolerable in a democracy that all that power and discretion should be exercised without significant democratic accountability and input. When making decisions about crowd control at large-scale protests, for example, there are important public policy considerations at play. The possibility of economic life for the surrounding community, access to education, healthcare, other important services, sometimes matters of international trade, and so on, that must play a part in decision-making about how to police those protests. So we've seen in a number of important judicial reports on policing, from Justice Morden about the G20, Justice Linden on Nipper Watch, and others, urging a more pragmatic allocation of decision-making power and certainly an increasing flow of information over an array of police activities. Unfortunately, though, many politicians, solicitors general, police services boards, others, have assumed that police independence should cover much more than just the investigation of crime. What's more, of course, there is legislative language in Ontario, Section 31(4) of the Police Services Act, that draws this sharp distinction between operational decisions with respect to day-to-day operations and policy matters. But I believe that broader understanding of police independence undermines the accountability and ultimately the democratic legitimacy of policing outside the area of criminal investigation. So how then should we demarcate areas where the police should maintain strict independence from areas where more government input is appropriate? Well, first, I think we should continue to ensure full police independence over criminal investigations, and we should do so in clear, unambiguous statutory language. But outside that area of criminal investigation, we should make clear, also in clear statutory language, that police independence is not a bar to the free flow of information to and from police services and boards, and to some direction from government. Making clear that these other areas of police operations are not subject to strict police independence will allow for a proper flow of information between police services and government. As Justice Morden pointed out 10 years ago in his report on policing the G20 summit, police services boards cannot perform their oversight function if they lack adequate information about the police services operations. And further, we should allow for more guidance and input from government in crafting policies, priorities, and objectives in these other policing areas. As we have seen at virtually every large-scale protest in Canada over many years, including earlier this year, the police lacked clear guidance about how to regulate those protests. The police need more and clearer legal guidance about how to deal with these large-scale protests and other critical points, as they're sometimes put. That said, I wish to acknowledge that it is very important that political guidance and the sharing and information should not become a road into partisan capture of policing. The police mission must be one that is subject to democratic oversight, accountability, and input, but not to become the servants of the government of the day. So, to that end, I think we ought first to make any government input clear, publicly accessible, and in writing, such that those that guidance can be subject to democratic accountability. Also, that where possible, organizations such as police service boards can act as intermediaries between elected officials and police departments. I look forward to the discussion later this morning. Thank you very much.
Thank you, everybody. It's tempting just to let you all ask questions of each other right now, but we're going to have slightly more structure than that. Our first set of questions relates to directions from police to police from government. And we've already heard a little bit about that in many of the statements. So the questions we're going to specifically look at are, what direction may police boards and governments legitimately provide to police? And in particular, I know this commission is interested in whether, specifically, may governments provide directions establishing priorities for which regions, police resources should be deployed during a major event that impacts multiple locations. So that question is before us. What decisions in relations to managing protests should be made by police alone? Is the policy operations distinction that we've already heard about meaningful, and can it be usefully applied? So with that, I'm going to ask Professor Kempa to start us off.
Thank you. So, Commissioner, I've made a real commitment to our panel chair to be as practical as possible in my discussion today and to really try to avoid getting bogged down in the theoretical weeds that have accumulated over the last 50 years on this particular topic. The issue of whether or not the policy operations distinction is even useful in terms of discussing what types of questions political overseers or civilian overseers can ask of police organizations, what types of direction these same bodies can give police, is a good one. And I think the metaphor that's come up over and over again over the course of this commission is the separation of church and state, where the idea was that political direction or questioning should definitely not cross some sort of a threshold which was understood as church throughout the commission. But the opinions as to what exactly the line was within the church were mixed from the evidence that you heard here. There were some that would have given you the idea that political overseers or civilian overseers should not even put a toe into the church, for example. And there were others who said, no, political overseers can come in and ask questions, but certainly not even make a suggestion or tell us what to do on any operational level whatsoever. So what I would suggest when we go through the history of the reports looking at these matters, at the level of civilian oversight bodies, police services boards, Linden is the report that is most helpful for us. Rather the Morden report is the most helpful for us. At the provincial level of political direction, it's Linden. And at the federal level, of course, it's the McDonald report and the more recent Brown report looking into these matters with the RCMP. So what I would suggest, rather than thinking of church and there's really no role for the state or political or civilian overseers inside the church, in fact, they're fully welcome in. They can ask questions about operations. They can give advice about operations at a general level, but they ought not to be allowed into the confessional, which is to do with the exercise of police powers specifically. So my answer to the question on whether that dichotomy is useful is I would say yes, but I actually prefer to think in terms of a trichotomy that just makes it a little bit more specific. So on the one hand, we do have policies, which is the domain of either civilian oversight bodies where they exist or the political ministers responsible, if we're talking about the federal level of the RCMP. Then there are plans, which can be conceived as the more general level of operations, where there is a legitimate role for any of these bodies to ask questions, demand answers to these questions, offer even suggestions about overall plans, but in the end, it is the final decision of the chief whether or not those suggestions will be executed at the level of plans on the ground. And then finally, powers. Powers, the exercise of powers is the most specific level of operations. This is the confessional, and this is where there is absolutely no role for civilian oversight bodies or for the political directors of policing, the ministers responsible. So, where we think about some of your more specific questions, for example, what directions may police boards and governments legitimately provide to police? Well, obviously they're setting policies, but in terms of an operation like something for a major protest event, there is no precise legal definition for what type of advice a board would give a chief of police on how to generally go about strategizing to deal with a mass protest. This comes from the Linden report as well. Rather, there needs to be a deliberative discussion process in place where these issues would be worked out. I know that very many would say it's difficult to define these things in law, and it's important to leave some space for your professionals to have room to work these things out amongst themselves within a framework. So I'm suggesting this is a general but specific enough framework, policy, plans, and powers, that within plans, there's the space for the participants to negotiate where the board would offer advice and where they would stop. Some of this would be common sense, for example. The board's members are typically not police professionals, so they don't have experience in deciding exactly where you would send contingents of officers on particular corners and so forth, nor would they even really have very many questions about those issues at that level for their chief. They would have questions about whether certain laws might be used as tools to be enforced, but not when and where those laws would be enforced or not. The timing and the ultimate decision to use those authorities would be for the police and the police alone. What types of information can boards or political masters ask for? On matters of operations, they should be asking questions about planning before and after plans are designed and executed. So before, again, the types of questions that a common sense approach within this framework would dictate would basically be what any good board of management would be asking. Chief, how did you come up with this particular approach? Were other alternatives considered? The board may have no idea what other alternatives would look like, but a good board of management makes sure that their executive officer in whatever branch has considered alternatives, for example. Is there any evidence to suggest that this would be a better approach than something else? The chief might simply reply, yes, this was a model that was deployed to good effect in protests in Seattle. We feel that there's some similarities, and that's why we're following this model here. It's a standard deliberative type approach in that sense. On your next set of questions here, we have a question, may governments provide directions establishing priorities for which regions, for example, police resources should be deployed to during a major event that impacts multiple locations? So the simple answer to that is yes, absolutely, and that's by Linden, where it's clear that the provincial government could issue such direction, providing they do so in writing, so that this direction would be publicly visible. If the public felt that this was unreasonable direction, the government would then be accountable for providing that level of detailed instruction to the police. Further, if the head of the OPP, for example, were to feel that those were unreasonable directions on the basis that they could compromise public safety, that commissioner would provide that explanation again in a public fashion, so that the logic of where the police were going, either before, if that could compromise the safety of the operation before, that could be explained after, where the police are going and why. What decisions in relation to managing protests should be made by the police alone? At the level of power, nobody should have any say as to how exactly, when, or in what fashion an operation will be executed by the police organization. So while a board may ask, are certain laws going to be enforced, for example, around the transportation of jerry cans of fuel, that board cannot direct that at a specific time of day you will begin enforcing these laws in any location in Ottawa or elsewhere for that matter. So finally, on that question of policy operations, I would suggest it is a helpful distinction providing you break operations down in terms of plans and powers. Powers are obvious and legally defined. Plans don't need to be legally defined. It's just within that space, there has to be that deliberative process. And if there is confusion, if the agreement as to what constitutes a plan breaks down, we do have mechanisms to take this disagreement to other bodies. So, for example, my understanding would be when the new COPS Act for Ontario is proclaimed, the Inspector General would serve this role advising police services boards whether or not they are within their rights to ask for certain information and to enforce compliance on the part of police chiefs if they were withholding information that a board was legitimately entitled to. But hopefully, with that sort of hanging over them, they would be able to resolve these things through the deliberative process. I think that the last thing I'll say about that is that it is only Ontario and Manitoba in their police services acts that specify any notion of police operational independence. I think it would be beneficial to remove the word operational entirely from any legal definition of police independence. Simply refer to it as police independence, referring to the exercise of police powers, and to specify that boards and political overseers are entitled to issue this type of direction at the level of policy and plans, providing that they do so in writing. For this reason, the private member's bill at the federal level for the RCMP, C308, does have some improvements, but is probably wrong-headed on its specific mention that nobody shall provide any operational direction to the RCMP on any level, although the rest of the private member's bill does have a lot to recommend it. So I can leave that there.
Perfect. Thank you, Professor Kempa. So Professor Pudister, I know that we've had lots of discussions about the policy operations distinctions, and Professor Kempa is already breaking it down to plans, policies, and power, which I think is an interesting way of looking at it. But would you share your thoughts on some of these questions?
Thanks. Yes. I want to focus more on the policy operations part of this questioning that we're going through right now. And I think the distinction that we tend to rely on, a policy on one side and operations on the other, is really not useful. And of course, this is not a novel opinion. This has been written time and again in commissions of inquiry, starting, I think, with the MacDonald Commission in 1981, but also more recently in the Missing and Missed report by Justice Epstein in 2021. So this is a conversation we've been having for a long time. The reports make it clear that it's difficult to draw a bright line between policy and operations in every scenario. And I would suggest that's not how things actually operate in practice, that we need to avoid these absolutes. So a few examples that are a little bit different than what we've been talking about so far is, if a government is concerned about the disproportionate use of force against a particular group, can it direct police policy and resources to address this? Or is that a matter of operations? Other examples that complicate this are mandatory charging policies developed by governments in issues of intimate partner violence, policies that have existed for decades. We also see examples where the police must have approval from the Attorney General to lay particular types of charges. So even just saying police operations is something that policymakers like boards and governments and ministers have no space, doesn't reflect how things actually operate in practice. As a political scientist, I'm really interested in those questions of policy, and I think police policy should be open to debate. It should be created and evaluated in a manner that ensures accountability for decision makers and transparency. As a student of public policy, I know that its development is not a straight line. We often speak of the policy cycle, the need for ongoing analysis and review of policies. This is important because we want policies that can be revisited if new circumstances or problems arise, so we can amend and revise those policies. But good policies will reflect as best possible the situation on the ground. Generally, when we're having discussions about police-government relations and the policy operations distinction, references are made to the principle of police independence that Malcolm mentioned earlier. Routinely, we see elected officials comment on the proper role of government as limited in the face of respecting police independence. Statements like, "We can't direct the police," or "We can't tell the police what to do," are not necessarily accurate. Here we see references to the police being answerable only to the law itself. In my view, this is not a helpful understanding for police independence. As was mentioned earlier, the Supreme Court of Canada discussed police independence in the 1999 decision R.V. Campbell and Charose. Here, the court articulates that when an officer is investigating a crime, they are not acting as a government functionary or agent of anyone. The court draws connections between police independence from the executive as fulfilling the constitutional principle of the rule of law. However, I want to emphasize that in this case, the court was only speaking on police powers of investigation, and the decision does not provide guidance for other forms of policing or the other duties of the police. I also urge us to think about the distinction between accountability and answerability versus that of control. My perspective is that there's need for more government responsibility in policing, certainly at the federal level, and not less. Police independence, or some prefer the term operational responsibility, should not be interpreted in a broad manner to cover all things operational, which I think Michael agrees with. Instead, it should be narrowly tailored to respect what are sometimes called the quasi-judicial role of the police: investigation, charging, and prosecution of particular individuals. In other matters, this is where the space for government and policy can come in. Democratic models of police-government relations recognizes that for some decisions of policing, it would be improper for the government to make determinations. Of course, for example, a government cannot say, "Arrest this specific person." But it is important for the Police Service Board or the relevant minister to be informed of aspects of police operations to ensure accountability and democratic input, and to allow ministerial authority to intervene in policy matters should they arise. Ministers have an obligation to develop policies, review those policies, and explain and defend them in the legislature. When governments do not fulfill their duties to provide direction, we have to rely on after-the-fact accountability mechanisms, like courts and oversight bodies. Based on my research, these are limited mechanisms for accountability. They only come into play after the fact, and they are difficult to ensure outcomes. Courts are highly restrictive. They're expensive, they're hard to access. And I can speak later, if necessary, about the very important challenges faced by police oversight agencies. Importantly, after the fact accountability mechanisms, the harm has already been caused. They have a limited function to act in a preventative manner, whereas policies set by police boards and governments that reflect on-the-ground operations can potentially serve a preventative function. So the final thing I'd like to say before turning it over to one of my colleagues is that I think public order policing can be understood as different from other types of policing and may invite greater government involvement, whether that's from the minister or the Police Services Board. And I'd like to articulate why this is different. Public order policing, we have competing demands and rights between those who are engaging in protest, but also third parties and other communities that can experience significant consequences because of those protests. There can also be concerns regarding access to public and government services, and of course, concerns about foreign relations. There might also be important considerations of protecting vulnerable groups. Here, the line between policy and operations becomes much less clear, and specific processes and procedures for government direction may be warranted. I'll leave it there.
Good, thank you. Mr. Teschner?
Thank you. Judge Morden in his report used a constitutional law analogy and talked about the importance of no longer seeing this idea of policy and operations as watertight compartments. I would certainly agree with that. I would also say that we have to stop seeing it as versus and start seeing it as and. There's a symbiotic relationship between the policies that are set, the priorities and objectives that are set by a police board, or in the case of other police organizations in Canada, by the government, and the way in which the operations are carried out by our law enforcement actors. Judge Morden also provided, I think, some very important thresholds that we should keep in mind. Not every instance of police action will merit the application of a board's governance and oversight function in the circumstance. And Judge Morden coined the term critical points. These were the threshold at which a police board or commission should become engaged because the policing operation that is being contemplated or unfolding, the event, is organizationally significant. It's not focused on one detachment or one division. It brings into play the entire police service and the command of the police service. Judge Epstein, in her report, Missing and Missed, expanded on Judge Morden's critical point definition and said that it should also include major operations that could have an impact on the police service's reputation. Again, classically a role that a board of directors would become engaged in. And also operations that are likely to have an impact on the police service's relationship with marginalized communities. But when I look at Ontario's Police Services Act, which I actually think is a pretty decent structure that requires perhaps some interpretive improvement, I'm less concerned about Section 31(4) that talks about the board's role and the board's limits. And I actually think a lot can be gleaned from Section 41(1) sub A, which speaks about the role of chiefs. And it says that it's the duty of a chief of police to administer the police force and oversee its operation in accordance with the objectives, priorities, and policies established by the board. So the board does have a role in providing direction. And governments, where there are no boards, have a role in providing direction. They do set the priorities and objectives. And Judge Morden said not just in general with respect to an annual business plan for the police service, but in the context of a critical point, when a particular event is being planned or unfolding. It's the board's role to establish, in consultation with the chief, what are the priorities for the policing of this event? What are the objectives that the police service should be seeking to fulfill? And what policy infrastructure is going to be put in place in order to carry out those functions? Once the board defines those priorities, objectives, and policies, the police service does its work. It develops the operational plans required to carry out that mission and achieve the identified objectives. I would argue, though, that the board's role is not over then. The board should stay engaged in the life of the operation. It should review what has been put in place by the chief, not for the technical elements for which it really doesn't have the expertise, but to confirm that the plans are consistent with the priorities, objectives, and policies, and importantly, that the board is satisfied that adequate and effective policing will be delivered in the municipality or jurisdiction for which it is legally, that is, the board is legally responsible. And of course, the board should ask questions about the plan. Was anything else considered? Why are you confident that this plan will work? If plan A doesn't work, what is your plan B? These are all kicking the tires that boards should do. So let's talk about this policy and operations distinction. Judge Morden in his report said that apart from being impossible to apply in its own terms, this statement does not represent what the statute, that is the Ontario Police Services Act, provides. Not only is it not meaningful, in my view, it's the culprit for decades of misunderstanding of the police board role, and in some sense, the reason that the full promise of independent civilian police governance and oversight has not been fully realized. A board can develop policies, priorities, and objectives that affect operations without impermissibly directing the Chief of Police with respect to core law enforcement functions. And policies and directions that have no impact on a police service's operational activities are meaningless. A board, of course, does have limits, and both Professor Kempa and Professor Pudister have talked about the case in Campbell and some of those limits. I would say that there could be perhaps a gloss put on the Campbell case. Really, where boards should step back and not direct police is with respect to the discretionary law enforcement power that police possess in our system. Whether that's a determination about who to investigate, how to conduct the investigation, who to arrest or not arrest, what search warrant to carry out, or what to do on the ground in the context of public order maintenance in a protest. These are discretionary law enforcement decisions that are within the full view and protected sphere of police independence, if you will. But the infrastructure in which it's carried out, the priorities, the objectives, the policies, that is the role of the board. And so I think in approaching it this way, rather than an either or, we can start to appreciate the symbiotic relationship that should exist between these two functions. Now, Professor Pudister talked about this in the context of policies, and she mentioned one that I just want to illustrate through an example: a disproportionate impact on use of force against particular populations. In Toronto, the Toronto Police Services Board put in place a race-based data collection, analysis, and public reporting policy that is lengthy, is dense, and is detailed. It's not just high level, it talks about what the priorities and objectives are in that particular space. And it compels the Chief of Police and the service through him to put in place action plans to identify the results of the analysis, the disproportionality where it's found. Many would say, in the past or even today, that's an impermissible intervention in day-to-day operations. You're telling the chief that they have to develop plans to address a specific issue, and you're creating the infrastructure in which that occurs? And the answer is absolutely. That's the role of the board. And the Toronto board has taken this role in the context of artificial intelligence, body-worn cameras, things that traditionally have been seen as the domain, the sole domain of the police service. But that infrastructure in which it's carried out is absolutely the domain of the board, in consultation with the operational leader that has the expertise to express how these things are going to impact the way they do their job in an effort to try and find a place that makes sense.
Thank you, Mr. Teschner. Professor Thorburn?
Yes, thank you. I'm glad to see that there is some convergence on some of these questions among the panelists. The question of what exactly the scope of government input might be into police operations turns on a number of questions. As Professor Kempa already pointed out, there's a big difference between providing specific directions and asking for information and even making suggestions and calling for a response. In those kinds of questions, I think what we need to do is keep in mind also, as Mr. Teschner pointed out, recognize that it is not a simple model of setting down policy and then leaving it to the chief to create specific day-to-day directions based on that, but rather a relationship of the flow of information in both directions and a give and take on questioning how those particular implementations are going to be made out. What I want to suggest, though, is that in certain contexts, the foreshortened time window of planning and execution is going to make that dynamic ever denser. That in some contexts, planning and priority setting can take place well in advance, that kind of discussion can take place in a way that is more easily insulated from day-to-day operations because it happens long before those day-to-day operations take place. In circumstances like the ones we saw earlier this year, in Toronto at the time of the G20 and a number of other events, sometimes the flow of information needs to occur much more quickly and decision-making as well. And so I think the easier distinctions that we're drawing as to whether or not we are making specific directions to day-to-day operations becomes much more difficult to draw. So bringing this conversation back to one of the questions we were first asked to discuss about whether governments should provide directions in establishing priorities for which regions police resources should be deployed in the usual case where timing is such that it is much, where we have time to set out broader policies with broader set of directions, that may not be required. In situations, in some of these critical point situations, the time window is going to be such that the flow of information, the flow of directions will be virtually simultaneous with some of those policy day-to-day decisions. So the kind of input, it would be unrealistic, I think, to say that the kind of input boards might have could be fully insulated from that kind of operationalization. So would it be best? So on those specific matters, absolutely. That although I would want to emphasize, I think that public order policing is a very significant step away from the specific law enforcement role of police with charging and so on. It is true that nevertheless we want to make sure that the government of the day is not giving specific directions on those questions. Given that time window, however, I think it's unrealistic to suggest that we can keep them quite so separate.
Okay, thank you. So I knew when I budgeted 20 minutes for operations versus policy, that would be too limited, and we could probably do another hour on that, and we won't, I'm sad to say. But I did want to just make sure, because I haven't been looking closely at our online component, whether Christian or Professor Leprecht wants to make any comment here, or Chief Raymer, because you haven't been in this discussion. So or can we move along to information share? Oh, Christian's got the hand up function. Yes. Professor Leprecht, please speak slowly.
Christian Leprecht au microphone. I'll just keep this brief, but I think we've had this theoretical and legal conversation. Let's take a sociological approach to this. And look at the G7, G20 in Toronto. On the Friday afternoon, it got rowdy, and the locals complained, and police took a heavy-handed approach. And we know what the consequences of that were. And so I think that response and the subsequent Morden report and so forth have had a chilling effect on the way we police mass gatherings ever since. And given that the chief in Ottawa at the time was present at the G7, G20, I think this very much would have informed his response. We also need to consider that in Ottawa, under the circumstances, with only the Ottawa Police Service on the ground, had there been, for instance, a more aggressive posture, there's a high risk that the police would have had a rebellion in his own ranks on his hands. And so this is why I think this dialogue and conversation is so important. And I think ultimately these questions of direction need to take into account also particular circumstances and also the size of a police service. And so inherently the question of direction, I think, looks differently in Toronto in a large service with large capacity than it does, for instance, in Ottawa of a more medium-sized service. And so trying to marry the theoretical and the legal remarks, I think, with the sociological reality and the reality of resources is I think, important to keep in mind for this conversation.
Thank you. It's very useful. Chief Raymer?
Yes, just one quick comment. What I would say is that police know and have training and expertise to execute law enforcement functions. But what we do is made more legitimate when it has the benefit of independent oversight that's framing what we do. And I think that's the essential ingredient.
Thank you. So now we're going to turn to information sharing between police and government. And some of these discussions, I think, will overlap. But we're going to focus more particularly on the following questions. What information may police boards and governments legitimately request from police? How can requests for information be distinguished from direction? Is there a danger of it being taken as an implicit direction? In what circumstances, if any, may the police decline to provide information as requested by police boards and governments? Is it a problem for departmental officials to speak directly to police below the chief commissioner level to get that information? And what about elected officials doing that, making those kinds of communications? What reports should police routinely provide to public authorities about their plans, activities in relations to protests? So there's a lot there, but Mr. Teschner is going to give us the first attempt at answering those questions.
I'm batting first on this one, I guess. Let me again pay homage to a great mentor of mine and somebody who I think made a significant contribution to this space, and that is Judge John Morden. In his report on the G20, he talked about a consultation protocol that should exist between boards and chiefs of police. And I'll substitute boards for government entities or ministers where there isn't currently, at least, a proper governance board. That information exchange was the first element of Morden's consultation protocol. Without access to all relevant information, the ability to ask specific questions about the operation and the plans, details that are contemplated, ongoing or completed operations, independent police governance bodies cannot fulfill their statutory function. A board can't ask a chief questions or turn its mind to articulating priorities, objectives, or policies about things of which it's unaware. You don't know what you don't know. And so the concern about a board not asking questions out of a misplaced fear that it will be accused of treading on operational matters, this is, I believe, as Professor Kempa put it, a timidity that has become dangerous to a board fulfilling its statutory mandate. It's created escape hatches through which the policymaker, that is the board, and the policy implementer, that is the chief, have each avoided responsibility. And so the burden, in my view, is on the chief to take initiative in ensuring that the board is properly informed about matters, past, present, or future, that fall under the purview of the board's responsibilities. And once he or she does so, that kicks in this consultation protocol, beginning with the information exchange. An information exchange, by the way, that is reciprocal, in that the board should be consulting with the chief on areas that it's considering. Judge Epstein, more recently, doubled down on this information exchange and said that only after a full appreciation of contemplated or completed operations occurs will the board be able to truly deliver on its statutory mandate to ensure adequate and effective policing. The only informational no-go zones, in my view, is information that a police chief is prohibited from providing to a board as a result of a specific statutory prohibition. So an example to that would be information about an ongoing wiretap operation, because that's prohibited under the criminal code, or where otherwise prohibited by common law. So an example there would be informer privilege, or thirdly, where they're precluded from doing so as a result of a specific court order. Otherwise, and I know some may consider this controversial, boards have and should have full access to all information. And that includes, for example, information about intelligence that a chief of police believes is important in helping define the plans for a specific event. And so, as Judge Epstein said, the answer to a concern about whether giving access to information could be seen as direction is not to foreclose boards from making non-binding recommendations, expressing opinions, or gaining access to that information, but reminding boards that when they're getting this information, they should be anchoring it to their priority, objective setting, and policy-making functions, to their mandate. We also need to remember that board members and chiefs of police are adults. If a chief of police believes that the way in which a board is engaging in a conversation goes too far and gets into the direction of police discretion, they should say so. And there are mechanisms in law and in certain statutes that if saying so isn't enough, that decision can be reviewed. But the board has a role to play. We cannot say that as a matter of law, boards are statutorily responsible and liable for ensuring adequate and effective policing, and on the flip side say that they're not entitled to a whole bunch of information about how policing is going to unfold in the jurisdiction for which they're responsible. Now, in terms of elected officials, my argument here would be that elected officials should not be reaching in to police leaders in order to understand what's unfolding, what the plans are, because it puts both the police leadership and the elected official in a potentially precarious position. Up to date on areas of concern, listen to their concerns, and help translate those concerns through their governance function to the chief of police. In terms of what kinds of reports or information police should routinely provide to public authorities about their plans and activities relating to protests, I would say that the model that we adopted in Toronto for the Freedom Convoy is a good one. This was clearly a critical point, to use Judge Morden's term. And the chief came to the board and said, we have something unfolding, and I want to make sure that you're fully briefed. And the board's institutional report at page 13 outlines the various types of information that the chief and his team provided in that briefing. The key context for the major event in operation, including known intelligence that's animating the operational planning, suggested priorities and objectives for the board to consider, the command and control approach that was going to be taken, especially if other police services from outside the jurisdiction were going to be involved, a lesson learned from the G20. Confirmation that the board's existing policies and legal authorities in place provided an adequate framework for the policing of the Freedom Convoy. A discussion about whether the service required any specific board approval associated with its planned operations. A discussion about the adequacy of the service's resources for handling both the major event and whether there was a need for other services to participate and lend support, and what the legal infrastructure was going to look like for that. Of course, also the adequacy of general policing services, so that while that event was happening, the board's statutory role to ensure adequate and effective policing generally in the city can't be forgotten. And so business continuity was discussed. And then importantly, public and stakeholder communications before, during, and after the operation. All of these areas of information were put on the table by the chief and his team, were discussed by the board, gave them an opportunity to ask questions, and ultimately to determine whether they were satisfied that the plan that was in place would ensure adequate and effective policing in Toronto.
Thank you. I'm going to let Professor Thornburn in a second, but I just wanted to allow Chief Raymer if you wanted to have any comments about the Toronto information sharing.
What I would say to you is that when I was appointed chief in August of 2020, one of the things I instituted was a morning brief to the executive director and the chair of the board to give them an idea of what was happening overnight and what we as a police organization and the city were being confronted with. And then, of course, when you had a priority incident occurred during the city, I would give them an immediate briefing as to what was transpiring on the ground and what we were doing about it, and keep them apprised just so that they were aware of what was going on. I found that it was an essential part of that information sharing, so that the board had an appreciation of what we were doing, what our capacity was, what our weaknesses were, what our resource issues were. These are all important things for the board to understand. Because it was important in terms that they oversaw budget recommendations, guidance, policy, and direction, and they had to be involved so that anything that they decided to implement what was going to be the operational effect of those decisions. So they had to be done in collaboration, and they had to be done with knowledge of actually what we were being faced with as an organization. So I just wanted to add that point into the importance of it. And with respect to, how can requests for information be distinguished from direction? And I think there's always an opportunity where the lines are going to be blurred there. When you look at the danger of actual or perceived direction from government to the police. But that's the origin of commissions and police boards, and that's why we need them.
Do you have any comment on the question about whether police chief may decline to provide information? Mr. Teschner gave us some examples of where it's statutorily barred, but do you have any reservations about other types of?
Yeah, no, quite frankly, no. I mean, there's things like informant privilege that we do, any type of, secret operations that we'll have going on, we don't discuss. We might discuss them after they're done and talk about some success, but not while they're undergoing, not while they're occurring. But other than that, as far as I'm concerned, there's an oath of secrecy, and the board cannot perform an effective oversight function if they don't understand what we're doing. Many of them, was mentioned earlier by the professor, are not police professionals. In some cases, we have lawyers, and then you'll have city councillors and people selected, like social workers selected by government to be on the board. But we have to inform them so they have an understanding. And without that information coming into them, it makes it very, very difficult for them to do their job. And then conversely, as to, I think one of my colleagues mentioned earlier, one of the benefits is that when we're having these discussions, and my team is letting them know what we're going to do. And by the way, we're letting them know that this is going to cost several millions of dollars, so you need to be aware of this. They're also making sometimes suggestions. How about, are you communicating with city councillors so they got an understanding of what's going on? They could become helpful to this discussion with the city. That's a good idea. And so we then got on and we made sure that we communicated with every city councillor and gave them a little bit of briefing on what was going to happen over the next couple of days. So that collaboration has benefits. It makes us much more successful in what we do.
Thank you, Chief. Professor Thorburn, thank you for being patient.
Thank you very much. Yes, I just want to say a couple of things. I think what we saw in the operation in Toronto on the Freedom Convoy was a convergence of greater democratic accountability and a successful operation. And so the extent to which information was shared and this not only provided greater input and democratic accountability, but also greater operational success, I think you can show that there's kind of synergies that are at work there. What I want to emphasize, though, is that there are plenty of places where that has not happened, and in the existing framework, other police services have felt still constrained, even 10 years after the Morden report, constrained in the kind of information they're sharing, not ensuring the kind of free back and forth of advice that Chief Rayner was just describing that you were able to benefit from in the operation with the Freedom Convoy there. And so what I want to emphasize here is a little bit, is quite similar to what I want to emphasize on that first question, which is that it's one thing to say, here's how we ought to operate, and there's another to provide clear guidance to police forces across the country and to police boards across the country as to exactly how to make sure that they live up to that. And this is where clear statutory language is helpful, and sometimes clear regulations. But on the level of the kind of successful integration of information and democratic input, I think that's a good model.
Professor Kempa, briefly, please.
I wanted to emphasize Ryan Teschner's point that the first point of entry for political influence is a board rather than direct political engagement by an elected representative in police matters, for the reason that that political engagement is rendered publicly visible through the board structure. So there's not a person in Ottawa, for example, who's not aware of the Police Services Board in Ottawa at this point. However, that's not the case for other police organizations. So OPP, the precise board structure is a bit of a mystery to most people in the province of Ontario. Most Canadians would not even be aware that there is an advisory board for the RCMP. At this time, through the RCMP's difficulties, there have been very few public statements of that body. So that is something that has been unresolved more at the provincial and federal level than at the independent municipal level of policing. That the primary port of call for political influence at the municipal level is a board. It's fuzzier at the provincial and federal level.
Thank you. Professor Lebrecht, very quickly.
Well, I'd say one litmus test is that we have a long way to go on this. If you look at police budgets, for instance, it can be exceedingly difficult, even for boards, let alone the public, to understand where exactly the money is going and where exactly people are being deployed. So that, I think, is an interesting exercise. The issues that were mentioned here, ultimately, this comes down to policy, right? So do we have and in Ottawa, an outdated major events policy? We need to establish these beforehand. So boards need to establish a policing designated major events policy. They need to establish a policy with regards to chief to board communications. They need to establish a policy on information sharing, sharing protocol during emergencies. And that ultimately looks different for different police services and different boards. But I think we've heard that Toronto here is leading by example, and there's a lot to be learned.
Thank you. And actually, that's a good segue to our next set of questions, Professor Lebrecht, where we're going to talk about different police services and different relationships. Because right now we've been talking about kind of the police and the government, right? But we actually know it's much more complicated. Some of the issues arising in this commission are much more complicated because we have the RCMP, the OPP, Municipal Police Force, the Ottawa Police, the Parliamentary Protectory Service. So we've got all these relationships going on. So we want to probe that a bit. Does the RCMP's relationship with the government and the minister change when it's in a contracting role, as it might be in other provinces other than Ontario, where we have the OPP, and we don't contract with the RCMP? What role does the provincial government play in those situations? And thinking more about police services boards, particularly when we have one force, the RCMP, that doesn't have a police services board, right? So we don't have that model. So we've got all these different forces with different institutional arrangements. How does that complicate everything we've been discussing? Professor Lebrecht.
So there's 4 police services in this country that I'm aware of that do not have the board structure that we are talking about. The RCMP, the OPP, the Sûreté du Québec, and the Royal Newfoundland Constabulary. And we see the challenges that raises, for instance, for the RCMP when we look at the Mass Casualty Commission in Nova Scotia. So that's, I guess, the first observation. The second is that boards can find themselves challenged. Most appointees to boards don't necessarily have the expertise, have the experience, and have the time that they need, because in most cases they're volunteers and they don't necessarily come from any sort of public safety background. And so I think there's a considerable gap, and that asymmetry often works for chiefs in the sense that chiefs can sometimes rule with an iron fist, especially when they face boards that don't quite understand their particular remit. The third is that it is the benefit of boards is that you have, as Mr. Teschner outlined, the ability to develop a strategic plan that sets outcomes, which we refer to as priorities, but that also defines outputs that are measurable. Those are what is known as objectives, and the way we translate those outputs is then through policies. And while that happens at the strategic level, it also needs to happen with regards to certain elements of operational elements as defined sort of by policy, as we had sort of in the previous conversation. Ultimately, information sharing on a high level is also always about trust. And I think we have serious challenges when it comes to trust within police services, between the chief and often associations, not to speak of any particular service here, but people will be familiar with forces in this country where this has come to the fore. So it's difficult, I think, for a force to be effective. And so boards ultimately need to make sure that those relations are working well. If you have a police service without a board, it is going to be, I think, more difficult to have insights on, in that regard. And you also ultimately need to have trust with other stakeholders and agencies. We'll get back to that in a couple of questions. I would like to close when we're talking about the relationships among different police services, that this ultimately are fundamental questions about police governance. And I would say that if you look at the recent webinar on police governance held by the Canadian Association of Police Governance, with some terrific interventions, I would say that police governance in this country is extremely challenged, and that one of the opportunities for the Commission here is to provide a way forward on police governance more broadly, because if we can remedy the shortcomings on police governance that were on full display during the Ottawa Convoy and the meltdown of the board during a local and arguably national crisis, then that means we wouldn't need to invoke emergency measures to try to remedy this, because ultimately we need robust governance mechanisms.
Anyone else want to comment on that set of questions? Oh, Malcolm.
Just a quick intervention. Just want to emphasize that it's all the more important, first of all, that we look at board composition, not only in their representativeness, but also in their ability to provide useful interventions and to know what questions to ask when serving on the board, to be able to provide useful insight. The model that several of us have been discussing this morning of flow of information, question and answer between board and the chief requires that the board members have a certain level of ability and knowledge of some of those areas in order to engage in that kind of conversation. I just want to emphasize also something that I think goes without needing too much emphasis, but the centrality of some kind of intermediary between elected government officials and police chiefs, that organizations like RCMP and so on, where we lack that board structure, there is a real concern about sliding from democratic accountability to too much a too close relationship with the government of the day.
Thank you. Oh, Mr. Teschner, sorry.
Just very quickly, I do think that this is a circumstance in which, even though they don't have constitutional status, municipalities can teach the rest of the country perhaps a lesson. Where there are governance gaps when it comes to independent civilian governance, they should be filled. The management board for the management advisory board for the RCMP was mentioned today, and while I think that's an important step along a transition, and I know that the more recent mandate letter to the Minister of Public Safety asks for enhancements in this area, I don't see any real barrier, statutory, legislatively, legally, or otherwise, as to why the RCMP cannot one day have a truly independent civilian governance and oversight body. And I would say the same for the others that Christian mentioned here. The reality is that those boards are the intermediary if they do their job effectively. And it gives real definition to some of the principles that we've been talking about today. And so I would just urge the decision makers and perhaps you, Mr. Commissioner, to give some consideration to that.
In the interest of time, I'm going to collapse some of our questions, and I'm going to turn now to a related issue with respect to all the varieties of different police forces, and that's about collaboration. So, Chief Raymer, I'm wondering if you could give us some insights about how collaborations between police organizations should be managed. Particularly, I know this commission is interested in the deployment of multiple police agencies' resources, how they can be coordinated during a major event, that especially one that affects multiple locations through the province.
I think when it comes to collaboration, there should be informal, as well as formal avenues to secure collaboration. The formal ones should be available when the informal ones, frankly, are not working. I find that we work very effectively in collaboration with our other police services. When, if you look at the Freedom Convoy in Toronto, during the course of that entire event, we had created public order hubs throughout the province because we knew, the participants had information and they were being very strategic in how they deploy. So they were in Ottawa, they were in Windsor, they were in Toronto. There's a reason for that. And the reason for that is because there's only limited POU assets in the province and they want to spread them around. That was very strategic on their part. So we create these hubs to sort of manage that, and we designate people to oversee those hubs and quite frankly, they work very effectively. When we were looking at resources in Toronto, the OPP provided resources, Waterloo provided some POU assets for us, and then Peel, York, and Durham were also communicated with, and they were going to help with business continuity if we were finding ourselves stretched and unable to meet our business continuity demands. Those were all just informal communications, easily set up, easily maintained, and they were reciprocal if all of a sudden an event ended up, say, being staged in Peel region. And so Nishta Riapa and Jim McSween in York, we're all having those conversations, very easy to move those assets around and work collaboratively together. And I have to tell you, it works very, very effectively. Now, when you have, and even despite what was going on at the time here in Ontario, and we had, you had what was happening in Windsor, you had Toronto, there was up London way as well, we had events as well as in Ottawa. We were managing those assets. When you look at what happened in Windsor, quite frankly, in my view, was textbook, and how that was addressed. And when you think of the lack of injury, people being, wrestling around and rolling around on the street and people in handcuffs. None of that happened. It was done very, very effectively. It was communicated what was going to be done, and then you made sure you had the resources in place to conduct it. And so that was all done with that kind of collaboration. I think sometimes when I talk about the formal processes is, within the Police Services Act, it's almost like an all or nothing thing. So in other words, if someone's not managing, then maybe the OPP are coming in. Well, I'm not sure that's the answer as well. If you look, I think I refer to Windsor again. If you look what was happening there, the OPP were brought in with assets to conduct that public order because they had the expertise in that area of the province to actually exercise that. And they did that in conjunction with the acting chief at the time. They sort of looked after, Windsor was looking after business continuity. The OPP came into the POU. They worked collaboratively together. It was very, very effective. So I don't think it has to be an all or nothing thing. I think if we were to hypothetically look at potentially being something so overwhelming and bad, if we are going to have the application of something more formal, it needs to be more easily done, and there needs to be a formal path to do that much easier, in my view.
Thank you, Mr. Teschner, briefly, please.
Yeah, just a brief point. I do think that the police service and police board sector would benefit from a little bit more rigidity in terms of the structure. Flexible, but structured. And so I'm aware, for example, that the Ontario Association of Chiefs of Police is working on template MOU or agreements so that where boards need to seek assistance from other boards for a particular operation on the basis of a chief's recommendation, there's already a framework agreement that's in place that boards and police services would be aware of. It would address things like cost sharing, training if there are any issues, command and control considerations, so those things are clarified, insurance matters if those things come up. And so having some of this on the ready that everybody is familiar with and understands means that the toing and froing that can sometimes happen during the life of an event is already been resolved. And so I think that there's an opportunity there, perhaps even to take that around the country.
If I could just, that's actually a good point, because I think when it comes to MOUs, quite often we're only looking at MOUs if there's going to be a financial cost. So in other words, if a region says, no, we'll send you the POU and don't worry about overtime or salary dollars, we don't bother with an MOU. But we do already, training is all done together amongst all those public order units. So they already train well together and they know what each other are doing. But the point of the MOU is generally, it's usually a financial component that initiates that MOU discussion.
Chief Raymer, I wonder if we could, we talked a lot about police independence pretty vaguely and generally, basically the police as a whole independent from government. Could you comment on police independence within the force? So incident commanders might have some independence, right down to the line officer. Every police officer has a scope of independence. I wonder if you could tell us more about that.
Well, I mean, all police officers are independent agents of the Crown, but when you have an operation and you designate an incident commander, the incident commander is in charge, not the chief. The incident commander is in charge, and he will direct all operations. Really, at the role of the chief, my only role is to oversee, ask questions if I have any concerns, and if I'm unsatisfied with the performance of the incident commander, to replace them. But my role is not to direct operations. If the chiefs were constantly directing operations across, you'd see us in court every day. And that doesn't happen for a reason. It's not our role in managing an event. You have trained experts, and those are the ones that you allow to carry out the event. We have expert planners. The operational plan is approved. It's not approved by me. I'm briefed on the operational plan after it's approved, but it's briefed at a senior command level, but not by me. And then it's operationalized. And then that incident commander there's a review team of chief superintendents that will sit and be an advice to that individual, to help guide them, provide some instructions, just as a secondary thing to help that incident commander fulfill the role, particularly in a very high-profile event. And that's something we found was missing in the G20, and it was something we implemented afterwards. But you have to allow the people that are designated in their role to actually carry out the operation. And then because when you designate who's clearly in charge, everybody else now knows who's making the decisions and what that chain of command is. And to me, that's what leads to a successful operation. When that G20 was going on, I was sitting in my command boardroom and I was watching what was happening on TV with with the fire chief, my deputy. We would brief our executive city managers every couple of hours just to let them know what was going on, because there were so many different assets that we were using throughout the city. But that was our role. And I might have a question or something, but that's it. The incident commander was in charge.
Thank you. Do any of the academics want to probe that a bit? But we've talked a bit about police independence. Does that complicate any views on that? No. Okay. Everybody's happy. So we're nearing the end of our time. We've got about 15 minutes left, and we've got a big section of questions next. I'm going to call a little bit of an audible here and restrict us just to the first two questions on the list, which are what changes to legislation might be appropriate, and what laws, regulations, policies, or norms governing the powers and responsibilities of police in relation to the public processes and their relations to public authorities, well, this is a long-winded question, should be revisited. So this is really the question, to think about the rules we have in place, the legislation. What would your prescriptions be if a commissioner was to make such recommendations? Professor Potter.
Thank you. Yes, so I'm going to suggest two. The first is not novel or new and has actually already been mentioned already. But I think one of the biggest challenge for police-government relations in Canada is thinking about the RCMP Act. So we've had a lot of really great conversation about what Toronto has done, and I think that's a really great model. And I think things are working well there. The Ontario Police Services legislation has some more defined roles about police-government relations and police independence. But when we look to the RCMP Act, in Section 5 in particular, we find none of this sort of guidance. So the current situation federally with the RCMP really lacks a statutory framework and articulation of police independence. It's unclear who can intervene and when, the nature and scope of that intervention. There's no clear guidance on what process should happen if there's a disagreement between the minister, so the Minister of Public Safety, and the commissioner. This, of course, results in a lack of transparency and accountability for those who are involved. Because of this, with the RCMP, our situation relies heavily on leadership and decisions of key actors, and that they will act in good faith. Here, I'm going to put the suggestion on the table that policy has an important place here to set a framework to deal with these situations in the future. Having defined, codified definitions of police independence can help address these issues and make it less likely that political or partisan interests on behalf of the government will come into play. So here I'm thinking we can look certainly to the legislation in Ontario as a good starting point. We also want to be reminded of the Supreme Court's decision in R.V. Campbell as a definition for that core function of the police. So here legislation could specify that independence applies to specific operations, such as specific arrests, investigations, and charging. I urge any recommendations to avoid just operations. I think we've spent a lot of time discussing why that's not a useful demarcation point. Thinking through this, it might be legitimate for governments to provide direction to policy as it relates to crime prevention, maintenance of public safety, delivery of services, general law enforcement, while other areas might be less legitimate, like enforcement of a law in a particular case, decisions regarding individuals, including individual police officers, and issues regarding individual members of the police service. Of course, reasonable, informed people may disagree where this direction from the government is proper and where it is not. But these are important conversations that can only be had once we take a step towards articulating these matters in legislation. And that legislation can be amended when it's clear that there are errors or gaps. This ensures that we don't have to start from scratch each time. I also agree with the proposal that's been put forward by Kent Roach in a variety of publications that this legislation could require directions be made in writing and be made public between the Minister of Public Safety to the Commissioner, and that these written directions are provided within a set period of time, unless, of course, it would compromise an ongoing police operation or investigation. But of course, that would be the limited exception. The second suggestion I want to put before the Commission and has come up on the side of some of the conversations we've had already is the consideration of a role of a truly civilian police oversight board for the RCMP. The RCMP roots are paramilitary in nature, and the force has evolved in a manner that is distinct from other police forces in Canada that have taken a more civilian approach to policing, like the situation in Toronto. Civilian oversight for the RCMP, in my opinion, is lacking and is out of step with other police services in Canada. The agencies tasked with providing oversight for the RCMP in matters criminal and conduct leave much to be desired. Creating a version of a police service board for the RCMP would help to increase democratic accountability and create opportunities for increasing diversity of those who are involved in governance and moving away from that troubling line, direct line from the minister to the commissioner that was mentioned earlier. A board can ensure that ministerial direction is appropriate and given when necessary. This can be helpful to transition the RCMP away from being a paramilitary organization, which was a recommendation from the recent House of Commons Standing Committee that examined systemic racism in policing. Membership of this board, like boards in Ontario, could have a combination of elected and appointed members, but appointed members could provide an important opportunity to ensure diversity of representation, especially of groups that have a history of distrust of the police and have experienced over-policing from the RCMP in particular. It could also include members that have particular expertise or lived experience that would be helpful in police governance. Like other police boards, the majority of these meetings could be held in public, receive submissions from the public. Similar boards could be considered for provincial jurisdictions in which the RCMP provides policing on a contract basis. I want to end with just one criticism that's going to be obvious. An important criticism would be that a police board would serve to diffuse responsibility. But given the framework that I've suggested and the public nature of these proceedings, the decision of the board and policies enacted would create more potential for accountability and lay true any overt attempts to diffuse responsibility. Of course, the minister would have to chair the board and answer to Parliament to maintain ministerial responsibility, but I'll leave it there.
Thank you, Professor Pedister. Professor Kempa?
Just to say that I agree with everything that Kate Pedister just said, except I would add one precision, or maybe a slight difference, which also follows Roach, and I think can be inferred from other sections of Campbell, that when defining police independence, you simply jettison the term operations altogether and define police independence in itself in terms of the exercise of their powers of investigation, arrest, and the laying of charges. Of course, they do that in consultation with the judiciary and the Crown, but that is the area, and that also follows, as I say, Kent Roach. To echo Kate as well, the importance of the minister being on any board for the RCMP is, I feel, replicated at the municipal level. Mayors should be on their police services boards, for two reasons. Number one, to align policing direction with broader city municipal planning, such as in areas of community safety and well-being, but also just to ensure that there is no perception or reality that there could be any political meddling in policing from any other mechanism or behind the curtains or whatever, other than through that board, if for no other reason to eliminate that public perception.
Thank you. Professor Thorburn?
Very briefly, I think Professor Pedister put it very well, and I, like Professor Kemp, I would say I endorse all of the recommendations that she made. And I just want to summarize some of this by saying that clarity and direction is needed, that there are practices that have been enormously successful, as we saw in Toronto Police Service's handling of the Freedom Convoy, but what we need is guidance to police services across the country to make sure that information sharing, these kinds of decision-making processes are widespread. The same thing is true of clarity, a board structure, and that there should be a board structure for those without one, such as the four organizations that Professor Leutprecht identified. And on the last thing on board structure, I think we can't underestimate the importance of representativeness, both the matter of the mayor representing the city's interest as a whole, but also of underrepresented groups who have a very important role in providing insight to police services.
Thank you, Professor Thorburn. Professor Leutprecht, did you?
So as I documented in my book, Public Security and Federal Polities, there is no other democratic federation in the world that either structures their police services the way Canada has, or that funds their police services that Canada has. And so inherently, there's only so much we're going to be able to do if we try to adjust governance mechanisms, as long as we have a model that seems rather peculiarly unique. And so I think those are questions we need to ask. We also have a federal and national police force where the commissioner has a span of control that is unlike that of any other national or federal police force in a democratic country across the world. I mentioned this in the context of the current review of federal policing by the National Security Intelligence Committee of Parliamentarians that was announced in February. And so I do think that the Commission may perhaps want to take the RCMP's and the Commissioner's span of control into consideration because I am not sure that this is a model that serves the public interest particularly well, in part because the RCMP is torn in too many directions. And when called upon, when a situation such as in Ottawa transitions from public safety to national security, and you need federal involvement on the national security side, we had a considerable, I think, breakdown in both resources and interagency collaboration. I also believe that there need to be clear qualifications and certification laid out for members of police services boards because that's essential to them performing their function. And so simply getting an appointment, I think, is not enough. We need to have, Canada is also a bit of an outlier in the way we generate police managers and police leaders. Many of the functions that in other democracies are managed by civilians in Canada are managed by folks in uniform. I'm not sure that necessarily serves the best interest. Similarly, on the leadership side, there's not a country, a federal country that I'm aware of that requires less in terms of education of senior police leaders that Canada does. And so we have this assumption that somehow people will acquire the skill sets for this extremely complex task. And the fact that only a couple of months ago, I believe 13 forces in Ontario had been looking for a chief of police suggests that we're perhaps not quite generating the leaders that the country needs under these particular circumstances. And I'll close on saying that effective policing, adequate and effective policing is essential for democratic legitimacy. And I think what happened in Ottawa severely undermined the legitimacy of our democratic institutions. And so it is inherently essential for the health of our democracy that the Commission find ways to ensure that we not witness these types of breakdowns again, not just for operational and tactical reasons, but for the broader reasons of safeguarding our democracy and our democratic institutions and our public's faith in them.
Thank you. We only have 2 minutes left, and the Toronto model has received so much praise today. But if you want to capstone it off by some comments,
Actually, if I could go first, I'll just be very, very quick. In terms of potential legislation, I think two things. There should be a board or commission for all police services that currently do not have one. I think that's essential. Secondly, sufficient protection for board appointees to do their jobs, to be free of political influence or the appearance of. So they just can't be all of a sudden removed from by a council motion. And I think, and more importantly, too, boards need the funding. They need the funding to have the people in place, some of the excellent people that we have in Toronto that really enables us to actually ultimately perform a better function. And then the Professor Lupert comment, something I've been advocating for now with the Ontario Association of Chiefs of Police, and that's really standard senior command training. It's something that I've met with the UK on, and they're going to do, I'm bringing some of their trainers here to Toronto in the spring to conduct some of that. And I'm just trying to sort of speed up the process and invite other organizations in. I think it's very much needed so that anybody who wants to be a chief superintendent, a deputy chief or chief has to have undergone this training. Right now our training is piecemeal. Some members are getting it, some members don't get it. It largely depends on municipal funding, and perhaps if you're federally or provincially funded, you're getting more access to training. If you're municipally funded, you're getting less access to training. That shouldn't be the case. It should be something where the province or federally, it's a standard either across the country or certainly at least in our province of Ontario, where we have that kind of standardized training. I think it would be very, very effective. And a final comment I make is we currently have 2 deputy chiefs in Toronto that are civilians. Our innovative and technology deputy chief, Colin Stairs, and our CAO, interim CAO, Savina Dhaliwal. And they are an excellent addition to the team, and they bring an expertise and an outside thinking that we have not we generally in policing, you don't experience. And in fact, I will tell you that Colin Stairs, our IT specialist, leads our race-based data discussion and is doing an incredible job with it. He's not a police officer. So there's great value in that as well. So I just wanted to echo the professor's comments.
Thank you, Chief. Mr. Tester?
Thank you. I'll just amplify some of the recommendations. First, Commissioner, I would say that harmonizing the approach to police governance through legislation and otherwise does not necessarily need to upset the constitutional order. And so there's an ability to make recommendations to bring to bear some of what was discussed today in terms of best practice. For example, the statutory roles and functions of police boards and commissions being made more clear. The definition of police independence that piggybacks off what happened in the case of Campbell, and I would suggest with my suggested modification, narrowing it more to the exercise of police discretion in the law enforcement function. A legislative definition of critical point with the attendant information exchange obligations. Mandatory training requirements for exercising the governance function and for chiefs and command officers to receive mandatory training on engaging with their governance bodies. And then the chief mentioned mechanisms to protect from a security of tenure perspective, if you will, board members in certain circumstances. Secondly, I would just say again, ensuring through legislation and other tools the ability of local police boards and services to seek assistance nimbly and in real time without compromising their ability to remain the police service of jurisdiction. Template agreements, MOUs, and the like established in advance so that some of the legal issues can be thoughtfully worked through and not necessarily dealt with on the spur of the moment. I've talked about, as many have, a fully independent civilian governance and oversight body for the RCMP, so I won't repeat that. And then I would say two things from my front row seat living within the world of police governance every day. All of these recommendations are great in theory, but you have to set boards and commissions up for success. And I would say there are two ways that you could potentially do that. One is, I am not aware of another government function where the tall order that boards and commissions need to fulfill are not fundamentally and adequately supported by professional civil staff that supports those boards and commissions. And I think resources and a consistency of approach needs to be brought to bear to ensure that part-time board members who are doing other things and may not necessarily have the expertise within the public service or otherwise are supported by independent civil servants. And the second would be to establish tripartite partnerships, municipal, provincial, federal, with a mandate to establish regional centers of excellence for police governance across Canada that can, again, bring some consistency to the approach that boards and commissions take, allowing them to still manage local issues, but on things like critical points, information sharing, consultation protocols with chief, approaches to certain policies. So there's a consistency of best practice approach. Those would be my recommendations.
Thank you, and thank you everybody for a very enlightening discussion. And I said at the beginning, there were no easy answers, but there was lots of consensus, and I think lots of things that the Commissioner can use and draw upon.
Okay, so I think we now take a break, and we'll see whether we got some questions, and we'll come back with those questions and maybe some others, and have a half hour of discussion starting at noon.
The commission is adjourned for 30 minutes. La commission est levée pour 30 minutes. The commission is reconvened. La commission reprend.
Okay, so we're back, and as I understand, we have a few questions. So I turn it over to our moderator.
Thank you, Commissioner. You'll be all pleased to know that your comments generated lots of questions, and I've got a whole list of things that we probably won't be able to get through in a half an hour. But let's try and move through them as quickly as we can. We talked a lot about prohibited direction. So when we talked about police independence, we said you can't interfere with investigations. Everyone basically has that kind of understanding. But how does that apply in the public order policing context? So what would constitute a prohibited direction in specifically that context? So not in investigations, but in public order. So the commission would, the parties would like to know about a sharper definition of that. So some examples that were proposed were whether should you negotiate with the protesters or act? Should you enforce provisions or not? What if the priority is established as Ottawa first, Windsor second? When does timing become an operational concern? So what are the types of prohibited directions you would see in the public order context? Professor Kempa.
Sure. So I would just say the moment it has to do with the actual carrying out or execution of the operation, that's the moment where the board cannot direct. So the board may have a policy that PLT or negotiation is an important part of mass protest management, but exactly when that negotiation would be carried out would be a police leadership decision, because they would be weighing in the safety of their officers, whether they had identified groups to negotiate with. But then the board would be properly asking questions if they felt that they didn't see, for example, PLT starting. They could ask why and demand a response. And if they were given an adequate reason along those lines, that's basically the end of the matter. And if they weren't given an adequate, they could say, well, when will it be starting? But fundamentally, they could not force the chief to begin on a particular moment.
Okay. Any other comments on that? Yeah.
I would just come back, Mr. Commissioner, to my suggestion that you add on to the Campbell definition or clarify it in terms of the exercise of law enforcement discretion. And so what happens on the ground during a protest in a variety of ways, whether it's what tactics to use, when to mobilize your POU, when to negotiate, when to cease negotiations, whether the circumstances don't, in the view of the person on the ground, allow for negotiations, even though that may be the policy because of safety risks or otherwise. These are all exercises of law enforcement discretion that should be protected once the operation is being carried out. And to use an administrative law analogy, the board should not fetter that discretion. They can, again, set the stage for it, set the context for it, identify the priorities and objectives, put in place policies, kick the tires of the plan, ask that certain things be reconsidered. But when the operation is underway, as Professor Kempa said, who's investigated, who's to be arrested or charged, whether someone should be arrested or charged, the number of officers to be deployed for specific tasks on the ground, the time frame for those actions. That is all the exercise of that law enforcement discretion.
So can I just follow up, and Professor Leprecht, I'll get with you to you in a second. Would we say it is a policy matter or an operational or planning matter to say you have to enforce, we want you to start enforcing the law, right? Instead of, I accept, Mr. Teschner, that you don't want to say you have to charge person X. Like that would be clearly an operational or a prohibitive kind of direction. But what about saying we want you to enforce the law? Like you're not taking as proactive an approach. Would that be prohibited?
I would argue that would be an odd direction from the board. Police officers have that independent authority and are required by law to enforce the law based on the exercise of their discretion. They are the experts in knowing what tools to use and when, And so a general direction to enforce the law, I think, is, as Judge Morden put it, one of those policies that actually are meaningless. That should be the starting point in any event. But when to enforce it, how to enforce it, what tools in the law enforcement toolbox to use, that is the discretion that we need to ensure police officers can exercise. Again, based on a plan with priorities, objectives, and policies staked out in advance.
Thank you. Professor Lebruck?
Yeah, I think this sounds good in theory, but in practice, look, I mean, when you have multiple police forces that are under different sort of jurisdiction, and each of them has sort of either been given some different directions or has sort of been given different priorities, I think the integrated command structure here is critical. And how do you generate appropriate oversight and governance of an integrated command structure, especially when you have some forces that have boards and some forces that don't? The other issue that I would raise is that the question here is a function also of do you have sort of just straightforward criminality, or are you facing a political protest? And police are the first to know that there is no law enforcement solution to a political protest. You will not arrest your way out of a political protest. And officers know that. And I think there would have been a rebellion of, initially at least, when there weren't enough resources of officers in Ottawa, had they just been told, you go and just arrest people. And so I think there needs to be, police will look for top cover in terms of what approach do you want us to take? Because if they take an aggressive approach, they know that there's going to be repercussions. So when in doubt, I think police will err on, we're here to keep to maintain public safety. So that's what we're going to do. And we're going to find a gradual strategy out of the situation that we find our ways in. If the political authority is unhappy with that approach, then it needs to set a clear signal that federally, provincially, and municipally, they will have the back of the police forces that are in place. And the governance asymmetries that we have make that difficult in Canada and especially in Ottawa.
If I could just jump in.
Thank you. Yeah, sure, very much.
You know, when you're having these events, I just want to say first off, the police position is always to do this safely and peacefully. No one wants to be rolling around on the sidewalk because everybody's getting hurt. And it's not just the public, it's the police officers as well. And so that's always the goal. And when we look on the events in Toronto on the one day, I believe the 5th of February, we had a number of very large trucks come down to Avenue Road and try to breach at Bloor Street, and they were unable to get through. But they ended up staying there during the course of the day. And as we briefed our executive body, which is the different city leaders, the mayor and the executive director, to keep the board informed, they were asking questions, well, what are you going to do? And we just said, well, the vehicles have stopped and people are demonstrating and we're going to facilitate peaceful demonstration. But consistent with our mission of all day, no vehicles were staying overnight. And so we discussed with the leaders, and by the end of the night, most of them moved on. There was a couple of people and large vehicles didn't want to move, so we brought the heavy tows into place, and then they went home. And so, because they saw that we meant business. And so that was the plan, but the whole goal was to do it peacefully. The board asked questions, and we told, no, we're just going to allow them to demonstrate peacefully. They're not hurting anything. We're there for the day, but we'll encourage them by the end of the night. We will help them move off. And that's exactly the way it did. But my point is that the board had questions, maybe coming from politicians as well to the board about what's going on. Community members are calling in and complaining about the noise in the trucks. We said, this is the way we're going to do it. This is a safe way to do it. They were satisfied, and that's the way it happened that day.
Thank you. Professor Thorburn.
Just a quick intervention. It's just important, I think, that we distinguish areas where the reason why we want to leave police independence is because of their kind of quasi-judicial function in making arrests and so on, from this area where mostly what we're talking about is expertise. And so in that area, we may want to insist we should defer to those who have expertise on the ground making these decisions. But the kind of dialogue that Chief Rayner was just describing, asking hard questions, saying, why aren't you doing thus and so, is entirely appropriate in a way that it would not be when we're talking about specific investigations.
Sorry, just wanted to off something that Christian said about integrated command structure, and I know Commission Council have asked questions about the deployment of resources to different areas depending on what might be emerging. I think it's important to be mindful of the governance structure that exists. In law, the Police Services Board of, in this case, Toronto, is legally responsible for the adequate and effective policing in Toronto. If assistance needs to come from other police services, it is vital, as Judge Morden laid out in the G20 report, for the board to understand what the command structure is. So that, yes, you can have an integrated command structure, but who ultimately has command and control of that event? And so through the MOU process that I suggested happen, these kinds of things should be worked out and should be clear. So there's never any doubt operationally and never any doubt from a governance perspective as to who has command and control, even though you might have multiple units involved at the same time.
There were some questions actually related to the request for other forces to assist and Section 9 of the Police Services Act being invoked. And there seemed to be some perhaps reluctance to do so in certain cases. And this got back to a comment you made, Chief Raymer, about all or nothing, right? The Police Services Act sometimes interpreted as all or nothing. Is Section 9 a kind of all or nothing? And this is for the panel as well, an all or nothing request. So once you invoke Section 9, suddenly the OPP is in charge of the operation and there's a kind of takeover of the operation. Is that the best way of looking at that section?
I think perhaps that's, the way it was written at one time, and maybe that's the perception. I think operationally that's not what happens. I know, when you're working with any of the organizations, and the OPP in particular, they come in and they provide assistance, and they work collaboratively together. And quite frankly, that's the way all of policing does work. I just think it's, when you look at Section 9, it's going to be in that rare incident that you have something that is beyond the capabilities or capacity of a particular jurisdiction, and then maybe for that particular event there needs to be some more clarity about what the roles are. But in the meantime, as Ryan had said, when we do this type of collaboration, there are, consistent with Morden, there are clear parameters that we have to address in terms of command and control and how things are going to operate. So it is happening already.
Okay, thank you. Professor Leprecht?
So there are other models in this country. So this is one approach. The other approach is in Quebec, where Quebec has a tiered policing structure. And my understanding is if, for instance, the equivalent protest had happened in Gatineau across the river, under the tiered policing structure, it would not have been the Gatineau police, because the tiered policing structure sets out competencies for police in light of the size of the police service. And so by default, the Sûreté du Québec would have had the operational command and control of a national protest. And so we either need to have a tier structure or, as the Chief and as Mr. Teschner have pointed out, need to have a clear governance set up for a for a joint force operation. And I think that was certainly one of the challenges that we saw.
Thank you. Any additional comments? So we have about 15 minutes remaining. Let's shift a little focus to the role to being a little more concrete about the role of the chiefs and the board in situations where there's a combined effort with multiple police forces and a whole bunch of other actions. So we talked a lot about some of the informal discussions and the trust and mature relationships, which is great. But what happens when that breaks down? Not just within a single police service chief and the board, but also when there could be competing boards, politicians of different levels, all those sorts of things. How do we deal with that? And in particular, how do we describe the role of the chief and the board with respect to the declaration of emergency, whether that was done at a provincial level or the federal level? Should either of those parties communicate with the decision makers? Should they go, or should it only be through the board? Should the chief be talking to the decision makers when it comes to the declarations of emergencies? That was a bit of a rambling question. Putting it together. Professor Kempa.
I could just start the conversation by saying that I think It is always open to the chief of a municipal police service to have direct conversations with the provincial police service, whether that's an independent or contracted RCMP, if they require more resources. The board would be the first point of communication through later the Inspector General, but currently the OCPC, to the Solicitor General, communicating that they were in some kind of difficulty. But it is not likely the role of the board to make a specific request for the enactment of either the provincial emergencies legislation or definitely the federal emergencies legislation, simply to indicate that they are having trouble providing adequate and effective policing. And then when asked whether that's limited to resources or also if there's some authorities that are missing.
Any other comments on that?
I would,
Fisher?
yeah, I would just agree that we have to come back to the statutory function and role of a board. Board is responsible to ensure adequate and effective policing. If through the information exchange with the chief of police it becomes clear that the police service of jurisdiction can no longer provide adequate and effective policing, then that information should be transmitted to decision makers who are considering other options that don't exist within the world of the board or the chief of police, and that would be an informational input that hopefully they would consider in arriving at their decision. But that information should be, again, because it's a political decision made by elected officials as to whether or not to declare the emergency, that transmittal of information should come through the board, but importantly, the operational understanding would be conveyed to the board by the chief.
Sorry, that was also exactly my meaning. I may not have put it as clearly.
Okay. So is the board then the exclusive conduit in that situation? Or if an elected, the person responsible, the parties responsible for declaring the emergency want to phone up the chief of the police and have a conversation with him, is that appropriate?
I would suggest that it would be far better for both the chief of police of the day and for the elected official of the day not to do that, but rather to use the infrastructure and the framework that is set out. The board has that responsibility. The board is the chief's employer. The board should be informed by the chief about what's happening operationally, and then the board can engage with elected officials to have those conversations and bring things back. That's not to say that with respect to matters that are unfolding in a particular ward or a particular riding, there won't be conversations with a police officer who runs a division and the local elected official about what's happening within that particular pocket of a city. But when it comes to the overarching board duty to ensure adequate and effective policing, and when elected officials are getting interested and engaged because they're considering other options, there is a conduit here, and so we should use it.
Any other? Oh, Professor Leprecht.
I think from a board's perspective, there's also a question about, is there a plan? So you have to be able to develop a plan B and alternatives. You have to present those alternatives. You have to present the trade-offs of those alternatives to the board. So there needs to be confidence by the board that the plan can actually work, or for the chief and the board to come together and say that this is simply beyond our capacity, and so we're going to need someone else to take command and control of the situation. So I think we can't just, based on the event, suggest, oh, we better call for an emergency. We need to see what an effective plan actually looks like, and the plan that both the chief and the board can either have confidence in, or say, we don't have the capacity to develop a plan, so we're going to need to scale this up, the classic sort of economies of scale, to a force that actually has the command and control capacity and the planning, logistics, intelligence capacity to run this type of operation.
Thank you. So one of the places we've seen consensus today is on the issue, the idea of an intermediary, right? Having a police board seems to serve important purposes and helps us reconcile some competing demands. So the RCMP doesn't, Professor Leprecht noted that only 4, he described it as kind of an aberration that there are these 4 that don't have the intermediaries, right? But another way of saying that is that the provincial forces and the RCMP don't have it, right? So are there other things like ministerial responsibility and the RCMP being at cabinet, right? They play a role there. Does that change the relationship such that you might not need that intermediary? Or does it suggest that those types of forces that are perhaps closer to ministerial control don't warrant that intermediary? That's a wide open question. Professor Pudister, you're smiling though, which I mean knows you have
Sure.
You have an answer.
Well, perhaps I'm just reiterating what I said before, that I think the relationship with cabinet is similar to the Attorney General in its relationship with cabinet, which would not be too far out of bounds because the Solicitor General used to be part of the Attorney General. And so when I'm speaking of the Attorney General, I'm thinking of the role in such that they represent the views of the Attorney General at Cabinet, solicit views from other members around the Cabinet table, but still hold that ultimate independence to make decisions. A model like that could be implemented for a Solicitor General or the Minister of Public Safety. But I suggest perhaps one other change would be necessary. Currently, we have a Minister of Public Safety that has a wide portfolio of responsibilities. Other jurisdictions, like New Zealand, for example, have a Minister of Just Policing. So perhaps in the scenario I'm suggesting, we have just a Minister of Policing that's fulfilling that duty. But I'll close in saying, I still think the more compelling solution is a civilian oversight board.
Okay. Professor Kempa, you're nodding along. Anything to add?
No, just that, in fact, that close relationship with the commissioner being a deputy minister has been specifically identified as a source of a number of the problems facing the RCMP, in that whether there is real or perceived political pressure on the deputy minister / commissioner, there has been a tendency to manage upwards to anticipate the needs of the minister in ways that may not reflect the needs, the downward needs of the organization. That was, of course, the main conclusion of the Brown Report.
Professor Leprec.
There's considerable symmetry in Canada with regards to the expectations attorney generals have and lay out for the RCMP. So they are quite detailed, and the most detailed, to my understanding, in British Columbia. In other jurisdictions, there is very little in terms of sort of the overall expectations. And so I think there's probably some of the expectations and the relationship also by the Ontario and Quebec attorney generals and the relationship with the RCMP, because of course in both provinces the RCMP normally only does federal and national policing duties. And so are there circumstances where the Attorney General will need to make those federal units essentially request that they become operational units, because if you're flying in people from British Columbia, it's going to take you a very long time to surge capacity in Ottawa. And so I think clarifying that relationship of the federal and national policing capabilities, and when that federal and national police service provides effectively contract quasi services, even in Ontario and Quebec, that relationship with regards to the expectations from the Attorney Generals needs some clarification.
Thank you. Just being mindful of the time. Would the panel have any comments with respect to the appropriateness of police involvement or participation or even information in negotiations between government actors and the protesters? So in a public order context where the government is, or actors in the government are seeking to have negotiations with the protesters, talking about mediating the problem, do the police play a role there, the police chief or intermediaries lower in the police?
Well, I see you're looking at me.
Sure.
I would
Chief Rayburn.
Yeah, the only comment I would make is that should never happen. unless it's done in conjunction with the police operation and with the full knowledge and support of the police to help to come to some type of peaceful conclusion or perhaps, I mean, it's done every day. We have 17, 18 protests every weekend in Toronto. And the first thing we do is we meet with the protest leaders. We talk to them and say, no, you can't shut down all the city, but maybe we'll facilitate a march around these locations and we'll help you do that. And we come to that. And I think that really, at the end of the day, that's what, by going to that level of government individual to help, it's obviously going to be a more significant event. But you're going to try to accomplish the same thing in conjunction with the police operation. So I think they need to be done in tandem if they are undertaken. And there's agreement that they should be done.
Okay, thank you. So we did have a specific question for Professor Pudister. You spoke early on about the significant challenges faced by police oversight agencies, and there was a question about whether you could elaborate on those challenges.
Sure. So my area of research on this is mostly on Ontario, but thinking about the jurisdiction of these oversight bodies and the SIU in particular, is what I'm going to talk about. And it's useful to focus on the SIU because that's the model that's been exported across Canada. And I think one of the biggest challenges in relying on an oversight body like that to provide accountability is that they have actually a very limited jurisdiction in which they can investigate. The SIU in particular is involved in serious injury, death, allegation of sexual assault, or the discharge of a firearm. Beyond that, there are other accountability mechanisms that come into play, but their jurisdiction is actually very limited. And I think the public has a very poor understanding of what they can actually do. The other significant area of limitation for the SIU and for many oversight bodies is that they don't have the ability to engage in systemic review, such as like we're having right now, to examine larger issues, to think about connections between particular events that they've investigated, or perhaps, if there's repeat issues with a force, the director can issue a letter to the chief, but they don't have the same powers to compel a full review. So their role is very limited in that they are reactionary only, very important mechanism of oversight, but are very limited in the ability to provide any, guidance going forward beyond criminal investigation.
Any other comments?
Sorry.
Sure, yeah.
Yes,
Commissioner.
If I could, I would just say certainly the SIU's jurisdiction is as limited as the statute says that it is. It's a criminal law jurisdiction. There are other players on the landscape that we have to also take into consideration. Of course, boards, which we've been talking about, which have a unique ability, actually, almost an unlimited ability in some respects, to review a number of issues, both with respect to complaints that are being brought forward because they have a statutory mandate to review the administration of the complaint system by the chief, and particular issues that relate to their policies or the implementation of their policies. A capacity, though, that requires, again, back to my recommendation, professional resources to actually have some oxygen. These are all great things in theory, but as a practitioner, I can tell you that not all boards across this country are in a position, in fact, very few, very, very few, would be in a position to actually carry these things out. And so if we're serious about them, then we need to appropriately invest in them.
In our final minute, does the panel have any concerns about, so we've been very suggesting that police services boards do provide an important function. Are there any problems with that where we might have some reservations about having that kind of model at the federal or provincial level? Or is it all goodness and light?
Well, no. As Ryan Teschner is alluding to, without proper resources, police services boards have not had a record of untrammeled success across Ontario or Canada, for that matter. And in fact, for example, in the United Kingdom, they've moved away from the police authority model, which is the same essentially as the police services board model for an elected local body, that through the theory of being elected has even greater legitimacy to intervene in operational type matters and so forth. So it is a question of whether, to evaluate whether the Police Services Board model is a good one for Canada, it's a bit unfair to look at the track record on the basis they've never had the training, resources, or clear explanation of their authorities to actually carry out their functions.
Any other comments? Nope. We're 1 minute over time. Oh, sorry, Professor Leprecht. Briefly.
Just to point out that ultimately it's up to the people to decide. We live in a democracy, and the people create the framework under which police, boards, governance, and so forth transpires. And so we can blame police, we can blame boards or whatever, but ultimately the importance of the commission and the inquiry is that it's a question of are the frameworks appropriate and are they fit for purpose? And the nature of the discussion today suggests to me that they are not entirely fit for purpose for the 21st century.
Thank you. That's a good point to end on.
Okay, well, thank you to all the panel members. It was very interesting. Made a lot of recommendations. Some of them may find their way into a report. I'm not quite sure which or whether, but certainly you've been very helpful in sharing your knowledge, sharing your expertise, and sharing your thoughts. It's very appreciated. As always, I learn a lot, and I have learned a lot today thanks to you all. So thank you to all the panel members, and special thanks to you, Professor Baker, for your moderation and I'm sure preparation for this, as everyone I'm sure has put a lot of time, and probably you a little bit more. So thanks again. We're going to adjourn until 2 o'clock when we have another panel.
The commission is in recess until 2 p.m. La commission est levée jusqu'à 14 heures.
Hey kid, don't ever let them get inside your head. They'll tell you what to do in life instead of everything you know that you could get. Don't let them guide your life towards regret. I'll fight for what I love with every breath. My past is filled with things I won't forget. I use them all to push me to my best. So treat the worst of times just like a test. If only I could go back in time, I'd tell myself that everything will end up alright. Just push yourself, test yourself, figure out what you like, and find your limits, don't be rigid, always work towards a prime. Surround yourself with open minds, people can change your life. A few friends with intent can help you feel alive. Find a passion, take some action, and with a little time, just be patient, make a statement, try to enjoy your life. They'll try to kick you while you're down. They wanna rise up while you drown. They wanna fill your head with doubt. They're silently scared that you'll figure it out. I'll make it look like I'm losing, won't bother hiding my bruises. And when they finally think you're wounded, then it's your chance to be ruthless. They don't wanna see me care. Anytime I make some progress, I can see that they compare. I think everyone's against me, maybe something in the air. Am I paranoid? I swear a void is forming and they're scared. I walk a straight path, not many can say that. I like to play fast, cross me and there's payback. You better pray that I don't see your face at any place that I go. I know you hate that. I've been doing fine, I'm not wasting any more time. I live for the fight and the climb, and I think that the pain that's deep inside is what defines. So I won't give up, I'm gonna make it to the top. I don't care what's in my way, I swear I'm never gonna stop. I could fall flat on my face and I swear I won't get back up, cause I don't deserve a thing and the road ahead is tough. They'll try to kick you while you're down. They wanna rise up while you drown. They wanna fill your head with doubt. They're silently scared that you'll figure it out. I'll make it look like I'm losing, won't bother hiding my bruises. And when they finally think you're wounded, then it's your chance to be ruthless.